now turn to Mr. Alan Shatter.
Thank you, Chairman. I appreciate the opportunity to briefly address members of this committee, of which I was a founding member and past chairman. I'm here today representing the Ireland-Israel Alliance together with Natasha Hausdorff, a distinguished English barrister and expert on European and international law who is a member of UK Lawyers for Israel. In my limited time slot, I focus on the substantive provisions and politics of the draft prohibition on the importation of goods bill. A more detailed analysis of the bill is contained in the Alliance's 8th of July joint written submission with UK lawyers and in my own submission of the same date. The bill is essentially a sectarian measure based on falsehoods, riddled with obscurity and anomalies, detached from historical, religious and present-day reality, and abandons all lessons learnt in our own peace process. While most of the discussion so far has focused on the relevance of EU and international law to the bill and its possible extension to services, the actual specifics of it and its enforceability have received little attention. It is that on which I focus, and Natasha will address the former matters. The bill's central proposition is to prohibit, and I quote, the importation of goods originating in an Israeli settlement, wrongly depicted by the bill's preamble as an international law obligation. The goods targeted are deemed by the the goods targeted are deemed by the preamble to be maintaining what it obscurely and wrongly describes as the illegal situation created by Israel in the occupied Palestinian territory. Even if the illegal situation depiction is accepted as accurate, as it is now known that the total value of commercial goods so imported in the 5-year period 2020 to 2024 came to €685,000, no credibility attaches to the proposition that such imports maintain anything. Rather than having any substantive impact, the bill is now justified and lauded by some as simply symbolic. Israeli settlements referenced in the bill from which imported goods are to be prohibited are an intended legal euphemism for locations in which Jews are present, reside or work on the West Bank, Gaza and East Jerusalem. The symbolism is to publicise the Irish government's disapproval of any Jews doing so, to demonise Israel and to portray Ireland as advocating that occasions be Judenrein, a policy which reflects that attempted in the last century in Europe by Nazi Germany. It is a denial of 3,000 years of history, Jewish, Christian and Muslim theology, credible attempts to permanently end Israeli-Palestinian conflict and present-day reality on the ground. In essence, the bill is the first initiative of any European government to enact legislation to intentionally boycott and discriminate against Jews since the defeat of Nazi Germany in 1945. This anti-Semitic symbolism is reinforced by the absence from the bill of any prohibition on the importation of goods originating from any other occupied territory. The bill, if enacted, will, however, not only impact its targeted Jewish-originated goods, but also those originated by Israel's Arab citizens, by those of all denominations, by Palestinians, and jointly by those of different backgrounds working together. The bill is intent on maintaining division, not contributing to conflict resolution, peace and reconciliation, and its malign application to industrial zones, such as the Barkin Industrial Park, clearly illustrates this. It is of no relevance to the tragic ongoing Israeli-Gaza war, despite some saying it is. The bill is riddled with difficulties and anomalies. Its reference to the Minister for Foreign Affairs designating by reference to postal codes the areas of its application means no member of this committee truly knows from exactly where originated goods are to be prohibited. The absence of any definition of originated creates a myriad of difficulties illustrated in my written submission. The enforcement role of our Customs Service and the bill's connectivity to the Customs Act 2015 raises significant questions I also address in my submission. Apart from the expenditure involved, the potential chaos and bureaucracy enforcement of the bill could create at airports and ports in its application to tourists, residents returning to Ireland and business visitors needs to be explored, as does its violation of agreed Brexit amelioration measures and the maintenance of free movement of goods between Northern Ireland and the Republic. In this context, the bill starkly resembles the unenforced Father Ted-like provisions applicable to the import of condoms contained in the Health Family Planning Act 1980. It may ultimately prove to be nothing more than fantasy politics and political theatre that does profound damage to the reputation of our state and which further undermines the credibility of anything said or proposed by the Irish Government to effect conflict resolution. I believe the committee should clearly ascertain what, if anything, is intended to be done to enforce the bill, the cost of mobilising our customs services to do so, the practicalities and legality. I believe, in essence, the committee should totally oppose the bill's enactment. Hopefully we can return to these issues.